Paul has really helpfully, in my opinion, taken us through the perspective of the court on Rule 39 applications, and I think he's given us some really helpful pointers as to where we could go wrong and where we shouldn't go wrong, and about the scope. I really want to come in as a practitioner taking cases and on EHRAC's behalf and say, these are the issues we've encountered, what should we do about them, or is there anything we do about them, and comment on some of the challenges. So I guess from our perspective, it would be the binding nature. We know these cases, we know these applications once granted are binding, but it's difficult to see how that works in fact in terms of enforcement. I also want to discuss with you a little bit the connection of Rule 39 with Article 34, the right of individual petition. Article 34, I don't know how much you know about that connection, but Article 34 says that the high contracting parties undertake not to hinder in any way the effective exercise of this right. So I'm going to talk about that, and I also, at the end, I'm just going to talk about the scope for development of Rule 39 and whether there is any, because we've tried to push those boundaries a little and been refuted by the court. So we'll just see if Paul can enlighten us on that. So Article 34 is a positive obligation, not just to refrain from interfering with the right, but to furnish all necessary facilities to make possible the proper and effective examination of applications. And as Paul said, in Mehmet Kulov and Askarov and Turkey, the court made the Rule 39 made clear that Rule 39 is a binding mechanism, a binding requirement once it's been ordered. Basically, what the court's saying is that Rule 39s play a vital role. Consider the application, and therefore, when the court has issued an interim measure, it's because a situation needs preserving or protecting, and in terms of the final application. And therefore that not to comply with the order is a violation of Article 34. So I wanted to give you a couple of examples of where Article 34 has been found to be violated because a Rule 39 has not been complied with. So in one of these cases is not our case, I don't think, and one of these cases is our case. Amirov in Russia was a case of the severely disabled former mayor of Dagestan. Actually, I think he was the mayor at this point. He had been former deputy prime minister of Dagestan, and he survived an assassination attempt and was paraplegic, I think, and in a wheelchair. And he was charged with murdering or attempting to murder or organising the murder of many state officials and detained. And he clearly, because of his medical condition, had very severe and complex medical needs. And a Rule 39 was requested, saying that he wasn't being attended to properly, that this was a threat to his health and possibly his life. And the court granted the Rule 39, and it required Russia to allow the applicant to be examined by independent medical experts, and it asked 3 questions. Now, this is I don't think this is an unusual Rule 39 in terms of an example of ill treatment in prison or health issues in prison, in detention. And we've had a similar experience. So the questions were that these independent experts were to answer is whether his care in prison was adequate to his needs, whether his state of health was compatible with the conditions of detention, and whether he needed to be transferred to a specialised hospital or a proper hospital, civilian hospital. And the Russian Federation complied to an extent. It provided a medical report by 3 of its own doctors who basically said he's fine, and they didn't specifically answer the questions. And the applicant did exactly what Paul has talked about. His representatives sent the medical report to a number of experts around the world, all of whom discredited the 3 doctors' report and said it was nonsense and that he was in danger to his health and it could compromise his life expectancy. But nothing, to my knowledge, on the face of the case was done about compliance with the interim measure until the final judgment, at which point the court looked at the fact that they didn't think it had been complied with and found a violation of Article 34, because although they had submitted this report from the 3 experts, they hadn't answered the questions and they hadn't dealt with the main issues. And they also found a violation, consequently, of Article 3 in that the medical treatment provided was not adequate and compromised his health. So that's an example of how a Rule 39 can play out in these instances. And I guess what I'm raising, and I will raise in the next case, is this satisfactory? Is this as good as we can get it? So in the case of Leyla Yunus and Arif Yunus against Azerbaijan, you may have heard of this case. Certainly any of you Azeri lawyers will have heard of the case. This was the detention of prominent human rights defenders in Azerbaijan, both of whom were relatively elderly, both of whom suffered from ill health and had a complicated set of issues to treat. Leyla Yunus in particular had severe diabetes that was quite advanced, and she had chronic hepatitis, among other things. And she wasn't receiving the medical treatment she needed. So we helped with their representation, and we, together with partners, submitted a Rule 39 request, which was granted. And the court ordered, I put the Russian Federation there. Of course, it was Azerbaijan. Russia is not to blame in this case. So Azerbaijan had to provide the applicants with adequate care in prison, and if that was unavailable, they had to transfer particularly Leyla to a specialist hospital. They were also required to provide monthly update. Please ignore all references to the RF in this slide. The monthly updates provided by the Azerbaijani government were very cursory. They were 1 or 2 pages. They were repetitive each month. And they basically said that both applicants had been seen and were fine, there was no deterioration, but they were totally unsupported by any evidence, any medical evidence. And we were hearing contrary things from the lawyers of Leyla and Arif. And actually we were hearing that their medical conditions were deteriorating and their situation was deteriorating, and they were very worried about it. So we sent a second Rule 39. We sent letters saying we think you should be asking for evidence to support these medical updates, and we didn't hear back. So we sent a second Rule 39 alleging non-compliance with the first Rule 39, saying that this evidence was unsupported. The court was therefore not in a position to judge the requirements it had set as to whether the treatment was adequate and whether they should be transferred to a specialist hospital. And that was rejected. And then came the final judgment. And in the final judgment, the court said that the purpose of the interim measure was to prevent degrading and inhuman suffering in view of their poor health and ensure adequate treatment. And the court went on to say that it agreed with our argument that the government's failure to provide the court with medical evidence regarding their health had made it impossible for the court to assess whether the Rule 39 was being complied with and whether the treatment was appropriate. It considered that the failure to provide the court with relevant medical documents, as we had asked, and with their updates, prevented it from knowing this and was a failure to comply. So there was a violation of Article 34. So from our point of view, the court basically agreed with our second Rule 39 alleging non-compliance, but had not granted that second Rule 39, had not been prepared at that stage to say there was non-compliance. Now, in a minute, I'm going to turn to Paul and say, is that because it can't do that? Was that not the way to pursue that? Or is it that the court's teeth only really come into being in Rule 39 in the final judgment? The court went on also to find that the applicants therefore hadn't received adequate medical treatment, and there was a violation of Article 3. So I guess from our perspective, there's a monitoring issue, and we appreciate that Rule 39 has predominantly dealt with one-off decisions by governments to deport or not to deport, to extradite or not to extradite. And therefore, either the Rule 39 is complied with, in which case the person isn't deported or extradited pending judgment, or they are, in which case the court presumably can do nothing until the final judgment. I would suggest that in an ongoing situation of ill health or medical treatment, there's a different scenario going on, whereby you're trying to take protective action that can be taken, if not today, it can be taken tomorrow, so that there's always a moment where compliance can be ordered rather than this one-off situation. So is there no teeth until final judgment? And is that too late, considering the purpose of an interim measure is preventive? I also perhaps should qualify, I'm not sure to what extent an interim measure is preventive. It's almost protective. It's protecting a situation pending judgment. But in a situation of ill health or ill treatment, that protective nature is also preventive, because if the Rule 39 is complied with, the ill health or the ill treatment should be made better. So there is a preventive thing which may prevent any further violation of. Interestingly, the Inter-American Commission, in its Article 25 precautionary measures, specifies a number of measures it may take to ensure compliance, such as timetables for implementation, hearings, working meetings, visits for follow-up and review. I don't actually know how those work in reality, but it would be interesting to see whether there's any scope for more measures on implementation at the European Court, although obviously we all appreciate that it's under huge pressure as it is. So another issue for us is the scope. So the interstate application in Ukraine against Russia, the court did apply a Rule 39 and a continuing risk of serious violations on the territory of Ukraine, and called on both parties to refrain from taking any measures, in particular military actions, which might entail violations of the Convention rights of the civilian population, especially with respect to Articles 2 and 3. Given the issues we find with monitoring in an Article 3 case about one person in prison, one does wonder what these obligations entail, because that's incredibly broad, and how on earth that will be monitored or enforced, or whether it's a warning shot across the bows of both countries. It would be interesting, again, to hear Paul's inside view on where he thinks that interim measure is going and the purpose of granting it. As far as possibilities for extension are concerned, we're always quite keen to push the court's case law on this, to push its development of these sort of measures. In terms of new areas we've noticed, R&R against Hungary is the protection of applicants on a witness protection programme that was downgraded because the first applicant, who was an informant, having committed crimes, had turned informant, had been granted witness protection for his whole family, but had breached it. And so the whole family was taken off the scheme and just literally given the phone number of the police to call. But they had other identities, and the children were now having to go back to school as themselves, and this clearly was putting them in danger. So the court ordered interim measures to protect their identities pending final judgment. Evans in the UK, you've heard, that's preservation of frozen embryos, and preservation, therefore, of evidence. We used this case to ask in EHRAC against Ukraine for preservation of a crime scene, and to require investigation, which is something that has been done in the Inter-American system, requiring investigations. This was a missile attack in a city park in Donetsk, which killed a number of people, including the mother and daughter, who were the victims in this case. And the scene was not inspected, and no evidence was secured, and there were bits of Grad missile lying around the park. We wanted the evidence inspected, we wanted it preserved, we wanted forensics to be done on it, and we were concerned that if this wasn't done, there would never be an effective investigation. But the court wasn't ready to make that step in a Rule 39, so that was refused. So again, perhaps we can ask Paul where there are possibilities for development of Rule 39 and where really we're knocking at a closed door. So from our perspective, in terms of our cases with you, that would be very useful to think about. I guess, Paul, first of all, in terms of the monitoring and compliance, so it seems to us that you've encouraged us to contact the court where we feel there are ongoing issues that haven't been dealt with. Maybe the wrong person picked up maybe somebody who wasn't prepared to get back in touch with us picked up our letters. Obviously, there's very many different registry lawyers working at the court. But for us, it didn't work even when we put in a second one. Was there something else we could have done, or is it that in these situations the court hasn't quite caught up with the ongoingness of the situation?
I think it's the latter. I think you made a very good point about the nature of Rule 39 and that it's protective rather than preventive. I think that really is the best way of encapsulating the idea of a risk of irreparable damage and what the court seeks to do with an interim measure. It's to protect or to freeze the situation. That's certainly how it started, because all of these cases started as immigration and removal cases, going back to the time of Söring, and I think even earlier in the case of the then European Commission. It wasn't designed for, and the case law really hasn't evolved to reflect the fact that it's now taken on this preventive dimension in health cases. And it's clear, as you say, that there is a real problem monitoring and the weapons that the court has in its arsenal in order to actually monitor ongoing compliance with Rule 39 measures. I would say that it is a real weakness at the court that its procedures do lack the sophistication that you would see in not just national laws international civil law, but also other international courts. I was quite struck by your slide on the broad powers of the Inter-American Commission.
It's interesting, isn't it?
And it really seems that the timetables is one thing that could obviously be done that the court doesn't do. Hearings, I mean, the court did conduct a lot of fact-finding in its early days, and European Human Rights Advocacy Centre has done one of the best studies in fact-finding, which did draw the conclusion that fact-finding has really sort of disappeared from the court's arsenal. That's perhaps a pity, and it may be that there is a case for the court actually evolving its own procedures to take these things up again.
But I mean, for instance, in the Leila Yunus case, a letter to the I mean, I'm not saying this would ensure compliance, but a letter to the government saying these monthly updates are great, can you back them up with medical evidence? Maybe that did happen and we weren't informed of it, but certainly to our knowledge that didn't happen. And that's not a hearing, that's not onerous.
I think perhaps the fault in that case was not to actually be writing letters to the government that required responses back, that always required action from the government rather than just requesting updates. But what perhaps could explain it is the need for the court to try and get these cases back onto the normal track as quickly as possible, so that you can get to judgment. Quickly. Because as you say, quickly, because as you say, the teeth are only really in the judgment. In terms of your other question at the end on the scope,
that's very broad.
I mean, this started 2008 in the South Ossetian War between Russia and Georgia, and Georgia's interstate case. And the president of the court then, John Paul Costa, made a similar indication in respect of that war. And I was against it at the time. I thought that was the wrong thing to do because, it is a structural weakness in the convention system that you have all 47 European states except Belarus as part of the system, and it's supposed to be a system of collective enforcement for human rights. But you have states that haven't resolved their disputes with each other that are part of this system, and they're supposed to be equally, enforcing each other's rights, when what they're really doing is violating each other's rights. I didn't think there was anything to be gained in Russia, Georgia from the court in the middle of a conflict where clearly people are thinking about other things, to suddenly try to insert yourself into it, not least when you have, the President of the European Union, the Secretary General and others going to Russia and Georgia and trying to find some way to end the hostilities. I thought that was bad in 2008, but it set a precedent, and all that's happened in Ukraine versus Russia is that the court has applied its Georgia versus Russia precedent to this situation, to, it would seem, no effect.
I mean, that's quite unrealistic, isn't it? I would have thought.
And it's illustrative that the court's only just completed its fact-finding hearings in respect of Georgia versus Russia. Where are we, 8 years after it? Where it's going back and taking evidence as to what general did what, and it's supposed to be 4 days, was it, in summer of 2008? And the court, presumably in 8 years' time, is going to be doing the same thing in Ukraine, Russia, trying to verify whether the Rule 39 was enforced in that case. In terms of your other questions about scope, I regard RR versus Hungary as interesting and novel. But falling within the existing scope of
it's still health and life, isn't it? It's still Article 2 and 3.
Irreparable damage. I think if I were to draw a distinction between RR and JUC, is that Rule 39, as it stands, still only applies to the substantive rights and not the procedural rights. So the reason I think, and I don't know this, so I'm speculating, but I think the reason it was granted in RR is that it's within the substantive right of Article 2.
It was a threat to life.
Whereas JUC is just the procedural obligation under Article 3.
But then that can prohibit, a case under Article, well, maybe not, but it can compromise a case under Article 2 by not allowing the investigation.
Yes, but it may just be a desire to keep it to the substance of rights rather, or the substantive dimension to rights, rather than the procedural dimension.
Because otherwise they may be inundated with procedural issues.
And detailed procedural issues as to, it's much easier to say don't remove someone from a territory than to give instructions as to how to preserve a crime scene. So it may just be that policy decision that has always informed.
Are there any areas you can see room for development?
Off the top of my head, I would need to think more about it, but just to say I would never exclude any new areas. I'd keep trying. See where there's nothing stops you making the request and having them refused. But if they're granted, then they build up precedents for the future. I'd have to think about that. But, perhaps eviction cases where there's a strong cultural component to them. That is an area I think that will develop.
And when you talk about eviction cases, do you mean where there's eviction followed by demolition?
Yes.
Yeah.
And where there's a cultural component to the demolition, so you're destroying, say, a Roma.
Yeah, so there's a discriminatory issue.
Yeah, whereas just eviction from, say, a flat in the middle of London, which can be met with damages by way of reparation, wouldn't meet. The more novel a situation, the more likely it is to be granted. So in a strange way, so keep trying. But I'd like to think more about areas that it could be developed.